You know, when the prosecutor gave their opening statement, one of the phrases that I heard them use was totality of the circumstances. And I couldn't help but think, as they used the phrase totality of the circumstances, how many facts, how many pieces of evidence that they omitted during that statement. I was sitting there and I was thinking, you know, they have framed this thing in a way that you listen to it and all that you hear are things, nitpicky things, that are bad. They've picked out each of the negative facts in this case and tried to present them to you as though they tell the whole story. This case is not about the totality of negative circumstances. It's about the totality of all the circumstances. I want you to know all the facts of this case, as well as I can do that within the next day or so. I want you to know all of the facts, whether or not they believe they're bad, or whether or not you believe they're not bad, whether or not I believe they're good. I just want you to have all the facts. I want them to be there in front of you for you to ultimately make a decision as to whether or not the actual evidence in this case shows beyond a reasonable doubt that Mr. Smith committed this crime. Whether or not he was in fact a less safe driver, and whether or not he was above a legal limit within 3 hours after driving. I think, honestly, that if you looked at all the facts of the case, we wouldn't even be here today. If the state were to say, I can honestly acknowledge what it is that Mr. Smith did right, what it is that the officer did wrong, what it is that the GBI did wrong in caring for the blood sample, they would then recognize that there is in fact reasonable doubt. If they acknowledged all the facts, they would look at this case and say, it's fatal to the charges against Mr. Smith. There's no way that we can show beyond a reasonable doubt, if we actually acknowledge the truth, all the facts in this case, that we can prove these charges against him. So what I want to do now is kind of go through with you what it is that the evidence will show and the problems that I believe that you'll see in the state's case as it relates to Mr. Smith. First, you're going to see that Mr. Smith was followed by Officer White for about 4.5 minutes down the road. It's a long, winding road down Macedonia Road. You'll see that there are periods of time when Mr. Smith clearly hits the fog line with the right tires on his car. And that's really important, because in just a little bit, you're going to see a video of the officer talking about Mr. Smith's driving. And the officer, whenever he's describing his driving, is going to say in a sort of laughing manner, hey man, you threw grass up on the windshield of my car. You were driving so bad, you were driving off the road. There's a video pointing straight ahead. At no point in time are you ever going to see grass being thrown up onto the officer's windshield. That's just one example of the officer misstating, exaggerating things that honestly do not exist on the evidence of this case. Another example of that is that he's going to talk about Mr. Smith's eyes being constricted, his pupils being constricted, which just means very small. And he believes that's as a result of some type of drug that Mr. Smith had in his body that was causing his eyes to be constricted. There's a blood test that's done. It shows absolutely no evidence whatsoever of any sort of presence of any drug in Mr. Smith that would have caused his eyes to be constricted. Again, that's another example of the officer just simply misinterpreting, exaggerating evidence that does not exist in the evidence of this case. Another example of it is this. On the walk and turn test, there are 3 different field sobriety tests that the officer does on Mr. Smith. There's a horizontal gaze nystagmus test. That's a test where he's looking for 3 clues in each eye, so a total of 6 clues. The officer runs his finger back and forth in front of Mr. Smith's face multiple different times. And what he's looking for there is involuntary jerking of the eyes. And you're going to hear about these three different clues that can be observed in that test. First, the important part is this. Whenever they start talking about windshield wiper, it's like a windshield wiper running across a dry windshield and it looking like he's jerking. At no point in time are you ever going to see Mr. Smith's eyes actually doing that. There's no video evidence of this whatsoever. And more importantly, I'm going to ask the officer point blank, is there any study conducted by anyone anywhere that says that you can actually correlate those clues on the HGN test to a person's actual ability to drive a car safely? Because that's what he's trying to do. He's trying to figure out whether or not Mr. Smith, based on the presence of HGN clues, eye test clues, whether or not his ability to drive is affected or compromised as a result of alcohol based on those clues. The candid, honest answer that you're going to get from the officer on that evidence is that there is no study done by anyone anywhere that says that you can correlate the clues on the HGN test to a person's actual ability to drive. That's the first test that the officer has Mr. Smith do. The second test that he has him do is what's called the walk and turn test. And it's important because the officer in this case says that Mr. Smith showed 4 of 8 clues on that. What the state didn't tell you whenever they were describing those 4 of 8 clues is that the officer sets up Mr. Smith to fail on that case, on that test. What he has him do is he has him put his right foot forward instead of his left foot forward. As a result of that, Mr. Smith is trying to emulate what the officer did in the turn of the actual demonstration the officer did. In doing that, as a result of the officer improperly setting Mr. Smith up, Mr. Smith has to take an additional step to get to his left foot being forward and making a turnaround with his right foot. He turned the wrong direction, took the wrong number of steps because the officer set him up in the improper position to begin with. Two of the clues that the officer says that he observed, quite simply, are just as a result of the officer's administration errors. As you watch Mr. Smith perform that test, what you're going to see is a normal, non-impaired person performing that test as well as can be done under those conditions, and in no way showing in any way, shape, or form that he's affected by alcohol. The third test that he has him do is what's called the one leg stand test. And I want you to know all of these tests are on video. You're going to see every bit of them. You're going to be able to judge this for yourself, and y'all are just as good at judges of whether or not a person's impaired, affected by alcohol, as anyone is, as that officer is. But look at the one leg stand test, because the officer says that he observed 2 clues on it, and I got to tell you, you can watch this video over and over again, and it's just not there. He performs as well as you can on the one leg stand test, and there's no indication whatsoever that he was swaying or hopping or putting his foot down or any of those things that we might expect to see from a person who's impaired or affected by alcohol. He performs that test admirably well, exceptionally well under those stressful circumstances. I think once you look at the way that he walked, the way that he talked, the way that he drove, the way that he performed exceptionally difficult field sobriety tests under stressful circumstances, you'll believe, as any sort of reasonable person would, that Mr. Smith is not impaired, affected by alcohol. That is count 1 of the accusation that Mr. Smith faces against him. That is the DUI less safe evidence. All of the evidence from driving to talking to walking to field sobrieties, that all relates to whether or not the state's evidence shows beyond a reasonable doubt that Mr. Smith committed the crime of driving under the influence to the extent that he was less safe as a result of alcohol. But let's talk about count 2, because at the end of the day, if the state were being honest with us and telling us, hey, these are the limitations of the evidence, these are the things the officer did wrong, these are the things that Mr. Smith did right, if they conceded all of those things, they would honestly acknowledge that we can't prove that he was a less safe driver as a result of alcohol. They chose not to do that, so be it. But the real reason why we're here is count 2, and that is the DUI per se charge, which is based upon the blood test in this case. And what I want you to know very simply is that the GBI has a set of rules for the drawing and caring for a blood sample prior to the administration of the actual test of alcohol on that blood sample. There are 3 basic rules that were violated in this case. They're very simple. The first is that the blood vial must have a seal on it, and that's from their rule. I don't make this stuff up. This is their own rules that they decided to be held accountable to. They did not follow these rules in this case. The first rule is that you have to have a seal on the blood vial. You're going to see a picture that is clear as day of the blood vial in a Ziploc bag as it's being transported to the GBI crime lab. That blood vial does not have a seal on it. It doesn't have the tape seal that is required under the GBI protocol. They violated their own rule in the performance of that blood test in this case. The second is that their GBI requires that blood vials not be shaken vigorously or very difficultly or very hard after it is actually drawn from a defendant. In this case, you're going to see a video of the phlebotomist, the person who drew the blood from Mr. Smith's arm, and you're going to see that they do not invert it up and down gently. It is shaking. It's exactly what the rule was intended to prohibit. And you say, all right, that's two possible violations of their rules. They're pretty clearly established on the evidence of the case. But does it really affect the blood test result in the case? And the answer is, I don't know. It's their rules. It's their rules that they decide to be held to, but they're just going to tell you it's okay to ignore them. Don't worry about it. Everything's okay. No big deal. The only problem they have in this case is that there's one rule that is really important that you're going to hear from our own expert that's going to talk to you about why it is that you need to refrigerate blood samples, why it is that the GBI has that sort of requirement, and how it is that it can compromise the reliability and validity of a blood test that's performed upon a sample that's not refrigerated. The GBI rules requires that after blood is drawn that it be refrigerated as soon as possible. That's exactly what the language of the rule says. I'm going to show you a slide of it whenever we get to the evidentiary portion. You're going to have that rule in front of you where it talks about actually requiring that blood be refrigerated as soon as possible. There's no question that is the rule of the GBI. The blood in this case, we're going to show you what's called a chain of custody. After it's drawn, it goes back to the sheriff's office. Then from the sheriff's office, it gets relayed over to the GBI crime lab eventually. Once in the crime lab, presumably it would be stored in a refrigerated room. The problem in this case is that you have a period of unrefrigeration prior to the arrival of the GBI, and then you have a period once it arrives at the GBI where it was actually taken out of the cooler, sat on a cart, and ultimately, before it was tested, more than 22 days had elapsed according to the actual chain of custody, where it was not refrigerated. Ladies and gentlemen, once you have unrefrigerated blood and you have the possible compromising of a blood sample, there's no amount of good testing on that blood that can fix that. There's no amount of good testing on a sample that is already compromised that can ever take away that problem. That's exactly what you're going to hear from our experts. Those are the problems with the blood test. Those are the reasons that we have for doubt of that. Once you look at all the evidence from the roadside, once you look at the way that he walked, the way that he talked, the way that he performed field sobrieties, once you look at how it is that the rules were violated with regard to the care for the blood sample, the lack of refrigeration of the blood sample, the failure to follow the GBI's rules prior to the administration of that test, we're going to ask that you return a verdict of not guilty as to count 1, DUI less safe, count 2, DUI per se. The third count that Mr. Smith faces is failure to maintain lane. What I want you to know that with regard to the failure to maintain lane, you're going to see evidence of him striking the fog line, that he actually hits a fog line with the right tires of his car. That is something that happened. Whether or not that constitutes failure to maintain lane, ladies and gentlemen, is up to you. Quite honestly, it's a hard decision. It's not a situation in which he is veering outside of the fog line. You're going to see that he strikes it. You all will have to decide whether or not that constitutes the lane of travel and whether or not that's a violation of the law. So thank you all for your time. I look forward to presenting the rest of the case to you.